Assalamualaikum. I hope that everyone is doing good. Alright, for today we are going to finish our last topic in our syllabus. Right, this is under chapter 6, information and access. Right, these are the learning outcomes for today's lecture. First, at the end of the lessons today, you are able to identify the necessity of the governments to disclose information. Second, a student is able to explain the situations where the information need not be disclosed because of a government's privilege. And third, student is able to distinguish the provisions for government's privileges applicable in England and Malaysia. So we are going to compare the provisions in England and Malaysia. Alright, for an introductions, okay, as everyone knows that, okay, we have enjoyed the fundamental rights of Malaysian citizens. Okay, we have Article 10 of federal constitutions, okay, which stated that, okay, that every citizen has a freedom, okay, has a freedom of information, okay, freedom of speech, okay, freedoms of assembly and freedom of associations. So these rights, okay, is conferred to every Malaysian. Okay, however, please bear in mind that this right, even this right is guaranteed in the federal constitutions under Article 10, but it is not absolute. Okay, so what does it means by this? Okay, because even we have freedom to speech. Okay, for example, as a Malaysian citizens, we have the right to say whatever we want, okay, as our rights. Okay, however, there is restrictions in regards to the freedom of speech. Okay, for example, we have Defamation Act 1957 that restricted our freedom of speech. Okay, so this act will protect the reputation of a person, okay, as a measure to avoid people from defaming others without valid justifications. Okay, so you cannot say whatever you like, okay, because this freedom is also subject to certain limitations, right? And this is also similar, goes to the same rights given under Article 10, rights to assemble peacefully. Okay, however, this right also has limitations. For example, we have the Statutes of Peaceful Assembly Act 2012, okay, read together with the Section 27 of the Police Act 1967. This is where, okay, freedom of assembly can be restricted if our action affects the federation's security and causing public disorder. So if our assembly will jeopardize of public interest, public disorder, alright, so our rights will be restricted. Okay, in regards to the informations, okay, freedom of information is the right to access informations held by public bodies. Okay, so we have the rights to access the information. Public may participate in the decisions making made by the governments. Alright. For example, we have rights to vote. Okay. And then What makes its importance here? Okay, this is important. Freedom of information is important for the purpose of accountability, okay, and to avoid corruptions. Okay, basically, the purpose is for a check and balance. Okay, so we as a Malaysian, we also has right to participate in the decision making made by the governments. However, again, even we have all these freedoms, but it also subject to limitations. Okay, the governments are privileged not to disclose information for the purpose of interest and state security, and it must be balanced. Okay, even we say that we have right, okay, to be informed of the um, decision made by the governments, the informations, okay, uh, the results of a complaint, for example, okay. However, this is also subject to limitations because the government possess a privilege. Privilege ni is a special rights given to the governments not to disclose certain information. Okay, so under the first subtopic is the government's privilege not to disclose information. So we are going to scrutinize the positions in England and Malaysia. So now what happened in England? Ah, so in England, the government's privilege has been applied strictly for the governments. Okay, the first case, we have Duncan's against Camelot and Co. in 1942. The principles that is very important in this case, you need to know this principle. The court is unable to question the government privilege at all. This is to ensure the facility and comfort of a department not to be equalized with public interest. Okay, based on this case, okay, it mentions that even the court has no power to interfere the government's documents, okay, to check for the government's information because the government has a privilege to do so. Okay, what happened in this case is that there was a submarine built by a contractor for the armed forces did not emerge in a sailing test. And the wife of one of the army personnel drowned claimed compensation because of negligence. And she had applied certain information. Okay, so this is the grounds of the case. The wife had applied certain informations, including the submarine plan to be produced before the court. Alright, so now she wants to take a look at the submarine plan that belongs to the governments, and then she wants this plan, okay, submarine plan to be produced in court. Okay, and the army, the governments, applied for government privilege not to disclose that information for the purpose of state security. And the House of Lords held that the information must not be disclosed on the grounds that the affidavit made by the concerned minister was final and could not be questioned. So basically, the rules and the government's privilege has been strictly applied in this case. Even you want to disclose the information in court, still cannot do so, right? Because it may jeopardize the public interest. Okay, so this is the first case in England. Okay, however, if you can see the next case, in 1968, Conway against Rimmer. So this case basically has renewed the principle in Duncan's case just now. So the general rule of the case is the House of Lords had examined the documents and held that they should be disclosed to the public. Alright. So what happened in this case is that whereby a court changed these conditions of government privilege, where the plaintiff was a police constable under probation. He was accused of theft but was later acquitted, and he claimed against the superintendent who made the allegation against him on the ground that it was made in a mala fide way. Mala fide means in bad intention. Certain documents were requested from the authority, but the authority refused to provide the information on the grounds that it related to the state affairs and could not be disclosed. Okay, why he needs the documents? Because he wants to look into the evidence of allegation made against him. Okay, and the House of Lords has that. Okay, the decision of the head of department could not be considered as final because the court will itself examine the relevant document without referring to any party and will itself come to a decision whether it related to state affairs or not. Okay, basically in this case, okay, a court has power to determine okay, by examine of such documents. So court will determine whether this document can be disclosed or not. Okay, not the minister, not the government itself. Right. So certain documents which cannot be examined by the court, such as cabinet papers, letters of external affairs department, state security, minutes of meetings between higher departments, and also documents in relations to the administrations of armed forces. Okay, so if the document is not related to this, okay, then court has power to examine, and then court may decide whether the governments can disclose or not to the public. Okay, so this is the important principle highlight in the case of Conway. Whether the document will be disclosed or not, the court itself will examine them and determine accordingly. Okay. Okay, as what happened in the case of Burmah Oil Co. against Bank of England 1979. So this case also followed the principle in Conway's case, whereby in this case the court gave the statement that the disclosure cannot be made because of public interest. So in this case, the court also determined whether such documents can be disclosed or not. Okay, so this is the positions in England. Next, we continue with the Malaysian position.